Testing, testing.
Yeah, yeah, yeah. No, I know you.
back on the record for case 9702.
There is one preliminary matter,
Okay.
and it has to do with the page limits for the brief. The parties did speak yesterday after the hearing, and unfortunately, we could not come to an agreement on what the page limit would be. The company is proposing 75 page, a 75 page limit. The regulations provide for 60 pages for initial briefs. Due to kind of the significant discussion in this case about the historic test year. OPC had also put in their bench DR a proposal for temporary rates. We figured the additional pages, the 15 additional pages that we're asking for, we would need to deal with those two new kind of significant additional issues. So the company is proposing 75 pages for initial brief, and I thought we talked about 60 pages for reply brief.
Anybody else have a thought on that?
Yes, Your Honor. We would prefer to stick with the 60 pages. The legal arguments are always there. The temporary rates arguments are always there. A lot of the legal arguments have been drafted already, not all of them, but some of them in the papers that have been filed. I see no need for 75 pages. They said 75 pages was the limit in the BG&E case, although AOBA was not a part of that proceeding. That was a gas and electric case, so it was considerably larger determinations, larger page numbers needed. So I see no reason to deviate from our standard practice and
Okay.
60 pages.
OPC agrees with AOBA. We believe that the 60-page limit under COMAR is appropriate. I understand that there might be more issues than Pepco anticipated at the beginning of these hearings, but I don't believe that they rise to the additional issues that were present in the BGE case, where I believe the page limit that was actually approved was 80 pages, as Ms. Francis mentioned, that included the entire rate case for a multi-year rate plan for the gas side of BGE's business. And it also included elements of BGE's gas distribution system, the stride adjustments. So we just don't see how Pepco would need virtually the same amount of brief length to make the arguments in this electric distribution case.
Staff wouldn't object to a 60-page limit that's currently in COMAR. We would also support a 70-page limit if that's a compromise the parties can make. Staff would note that in every other MYP, save DPL, the page limit was increased by some degree or not from the COMAR 60-page limit, just by the nature of an MYP proceeding over a traditional rate case.
Okay, so I think I am going to take up the offer of splitting the difference, so to speak, so we'll do 70.
Right. The next item, I believe, is for the company to enter into evidence the response to the bench DR. We filed that yesterday. So I am going to mark for identification as Pepco exhibit number 94.
Actually, 95.
The company's response to the March 8th, 2024 bench data request.
I'm sorry, Your Honor, did they say 95?
It should be 95 according to my count. So.
Okay, apologies.
Yeah.
And I would like to have Pepco exhibit number 95 admitted into evidence.
So admitted. I think so, yeah. Yeah, because we just printed the electronic version. So.
Your Honor, That was just a bit too quick for me. I have no problem putting this into evidence, except the evidentiary part is the part that was written by, was the data request response. The first few pages are legal arguments.
I understand, but I
No, I'm
did it
not
for-
objecting, I'm just making the
Yeah.
statement. That's technically not evidence, but rather argument.
Okay, that's fine. So noted.
We also have an exhibit that we're not going to enter into evidence, but it will be something that company witness Lemming will be referring to. So I'd like to hand those out now just to not kind of disrupt Mr.
Okay.
Lemming's time on the stand. And what it is a blown up portion of Appendix 2 to one of your orders that describes in a graphical representation the process for AIFs and reconciliation. So it'll be helpful to refer to that when Mr. Lemming is speaking.
Okay.
Now, is that the same chart as this? Okay.
Yeah,
okay,
it's just
okay,
a lot bigger.
Okay, good.
You guys have access to paper printers too.
Oh, I still have it.
If I had photos.
Okay.
And Your Honor, at this time, the company would like to recall Mr. Robert T. Lemming to the stand. And just to clarify, Your Honor, Mr. Lemming is being recalled solely to walk the commission and the interveners through the bench data request that has been admitted into the evidentiary record as Pepco Exhibit 95. Also, just to respond to the additional information that's been provided in response to commissioners' questions on the various items. I believe the witness is still under oath.
Yes.
Okay. Good morning once again, Mr. Lemming.
Good morning.
Do you have a copy of the company's response to the commission's bench data request that was issued on Friday, which has been admitted into the evidentiary record as Pepco Exhibit number 95?
Yes, I do.
Okay. Could you please explain the company's response regarding whether we have the information in the record that is necessary to convert this proceeding to a traditional base rate proceeding?
Certainly, and I believe our response is fairly consistent with what you heard from Mr. Efron yesterday from OPC, that we do not have the evidence in the record necessary to convert this to a traditional base rate proceeding. And specifically, I think you've heard me note there's things like construction work in progress, AFUDC, et cetera, that are not included. And we've also, and I don't intend to walk through each of these, but I've noted there's about 18 pro forma adjustments that we usually would file and include in a traditional base rate proceeding that are not included here in the MYP application.
Okay. Why do those adjustments need to be made to the historical test year that's been filed in this case to form the basis for a traditional base rate case?
Certainly. So, and I think we've had a little bit of discussion around this, but want to make sure the point here is as clear as possible. In a historic test year environment, we look back to, or no, I'm sorry, in a traditional base rate case environment, we look back to an historical actual period of time as a foundation for looking at a utility's cost of service. we've developed a number of precedents in Maryland over the years to make adjustments to that test year in order to make it more representative and reflective of the period of time that rates would be going into effect under that traditional base rate proceeding. So they kind of, if you will, alter that past period of time to make it look a little more like the future to the extent possible. If we were to include all of those adjustments in a multi-year plan application and then use that as a starting point to then build on for the future, we'd effectively be double counting all of those increases we would expect to see over time and misstating and overrepresenting what our cost of service is. So I tried to discuss this a little bit on Friday, but that's some of the distinction about why you don't include these things in a multi-year plan environment to make sure that you're not kind of double counting the impact of some of these adjustments.
Mr. Lemming, what is the timeline that the company needs to make these adjustments to the filed historical test year in this proceeding in order to file a traditional base rate case?
It would take us
Commission?
about 6 to 8 weeks to perform these analyses.
Okay. Now, have you had an opportunity to review OPC's bench data request response, which has been admitted into their record as OPC Exhibit number 34?
Yes, I have.
Okay, and were you listening yesterday when Mr. Efron offered his oral testimony?
Yes, I was.
And do you have any comments with respect to his proposal?
I think I spoke a bit about OPC's proposal on Friday. Noted some items around construction work in progress. I'm not gonna necessarily rehash all of those for you here today. I would just note I think there was some discussion between council and Mr. Efron around OPC's proposal in its totality, in that there's several recommendations therein with respect to ROE, depreciation expense, other adjustments to capital and O&M that OPC is reviewing and advocating for, and would just ask that each of those positions be kind of looked at individually and assessed on their own merits as they've been presented.
Okay. And did you also either witness or listen to the oral testimony of AOBA witness Timothy Oliver?
Yes, I did.
Okay, and do you have any comments on AOBA's proposal?
I certainly appreciate the forward-looking nature of the proposal from AOBA. I think listening to the testimony of Mr. Oliver, AOBA's also indicated that they reserve their right to kind of present their final position on brief, and so we'll certainly don't know that we have the final proposal in front of us, and we'll certainly look at that brief and respond accordingly on our reply brief. One thing I might want to touch on too with respect to both of these proposals, there's been a lot of review and comparison of the revenue requirement comparison chart that we have, and I just want to point out one thing for clarity, if I might, on that chart. There's a position for Pepco on that chart, and while we had filed this case as an MYP, there's an aspect of that chart that would be altered under a single year stated rate, if you will. If we were to get just a stated rate that stays in effect until we come back in for review, there's an item that would need to be removed from that chart, and that is the tax offsets that we have on there. One of the things that we're able to do in a multi-year plan type environment is look at ways to smooth increases in the rates over time, right? And so we looked at accelerating certain tax benefits into year one to reduce the impact of that year one increase, then be able to kind of smooth and adjust that into year two. If we don't have any sort of mechanism to be able to change that rate and provide that smoothing over time, we wouldn't be able to kind of accelerate those tax benefits, and so that item would have to come off the Pepco chart. I think OPC reflected on their chart that they removed that tax offset, and just want to note that would also need to come off the Pepco chart as well.
And Mr. Lemming, does the company have a position on staff's proposal that's been submitted in their testimony?
Yes, we've reviewed staff's proposal and think that they've taken a very balanced review of the proceeding, taken a fulsome review of all issues in the case, and would support staff as position as balanced in terms of considering all of the various interests of the parties and stakeholders in this proceeding, and support that as such as a balanced review of the case. I would note that I think the commission also has some discretion in terms of what they ultimately authorize in terms of the duration of an MYP, if that's the commission's election. I think the rules are stated that they may approve one of up to 3 years, and so would just like to offer for consideration, that I think that's a discretion the commission has as well.
And finally, Mr. Lemming, have you been following the questions from the commission concerning how the reconciliation process works and when the prudency determinations are made?
Yes, I have.
Okay. Can you please clarify what the company is requesting the commission to consider with respect to the reconciliation and prudency of costs incurred under Pepco's last MYP?
Certainly, and I think this goes to the Appendix 2 to Order 89482 that our council passed around to everyone. I think within that order, paragraphs 79, 80, and 81 really spell out the reconciliation and prudency review process in detail. But I think this chart, and I have it blown up so I can try to point at and walk through folks here. This chart, I think, represents a nice graphical representation, at least of how we've interpreted the reconciliation and prudency review process to be intended to work in a multi-year plan construct. And so wanted to walk through this, and certainly happy to talk through any questions that folks may have on this. I think staff witnesses Austin and Riley also did a nice job of kind of talking through this yesterday. But this really, to us lays out, you kind of have your MYP timeline on here. And I think if we look at year 1, year 2, year 3, that's really meant to reflect our MYP that was approved as MYP1, if you will, under case number 9655. And this shows at the end of year 1 and the end of year 2, we would file an informational filing 90 days after the end of that MYP period. If you then go to the top of the page, it's noted that we would file a rate case, and here, this was what I alluded to on Friday, that the rules around procedural schedules kind of changed as we were developing the MYP process, but at the time it was 210 days to hear a case. We would have filed a case such that the outcome of that case, new rates could take effect as this MYP expired. And you'll see some kind of color coding on the chart here. What we've interpreted as the commission's order to say is the items in blue here for all completed periods. And for us, that's rate year 1 and rate year 2 of our first MYP, and it's consistent with what we saw in the BGE proceeding. We would bring those completed periods into the next rate case for review for prudency and reconciliation of those costs if deemed to be prudent and appropriate for recovery through the MYP adjustment rider. If you look off to the kind of end of that timeline chart, there's a reddish kind of shaded out section. I think that's meant to represent, as we see it, the period of time where we don't have actuals available yet, namely rate year 3 for us here today. And those are the items, as noted here, that would be reviewed for prudency and reconciliation during that final reconciliation. That would be filed 120 days after the MYP ends. So that's the July filing we talked about a bit throughout the week. So that's kind of the timeline that we've always understood and why we've included years 1 and 2 in this proceeding, and our view that year 3 would be handled in that final reconciliation. I will also just note, and again, happy to answer any questions on this. I think there's questions of what exactly are we reviewing for prudency? And I think it's our view is you look at a revenue requirement, right? It's based on our average rate base. It's based on our operating expenses in a period. In terms of average rate base, those are assets that are in service, used, and useful. And so those would be any projects that have been completed, placed into service, and we are saying are used and useful for customers and seeking recovery of those. Within the reconciliation process, there's a lot of capital expenditure detail that the commission has required to be presented for review. And I think that allows us to do a couple things, right? We can look at those projects that were completed and work to assess those for prudency. There will then be other projects that are ongoing that might be completed in year 3 or even into our next MYP. Those aren't necessarily being reviewed for prudency today, but parties are able to look at those projects and say, hey, how are we doing on those? Are we sticking to our budgets? Are things changing? And they can use that information along the way to really assess the life of the project, how it's executing, have we managed it well, managed it poorly, et cetera, and be able to form their at least one data point to help them form a basis for their opinion around prudency to be able to leverage that in the ultimate prudency review and reconciliation that specific project falls into when completed. And so I think that's the distinction I think is important to draw, that we're seeking prudency review of the projects that have been completed. And those that haven't, parties are getting some information to see how they've been going to inform their future review once they are completed and put into service.
Thank you very much. And that's all, Mr. Chairman. Mr. Lemming is available if there's any questions.
Well, actually, let me have the parties go first, then we'll ask. So, AOB, have any questions?
No, Your Honor, I think the points that have been addressed by Mr. Lemming now, I think AO was prepared to address in our brief. I don't have anything new for today.
Okay. OPC?
Yeah, I have some questions, Your Honor. Good morning, Mr. Lemming. How are you?
Good morning. Good. How are you?
I'm good. I wanted to ask you some questions about the bench data requests that you sponsored, but before I do that, I just have a few questions about the rejoinder testimony that you just provided. One, you mentioned something about staff's position in this case being reasonable, and I was just curious. I think I misheard or I didn't hear whether you were saying that you are adopting staff's position.
No, we are not adopting staff's position. We are still standing behind our position in this proceeding. We think we've, excuse me. We stand behind the plan that we filed and thinks it's in our customers and stakeholders' best interest. But we think staff's is reasonable in terms of balancing, the interest that we've raised versus other parties is the point I was trying to make there.
And so, if staff's position was adopted, it would be reasonable.
I think it would be reasonable for consideration by the commission.
All right. And then you also mentioned that the commission could set something shorter than the 45-month MYP period that the company is asking for. And are you saying that the company would support that?
The company supports the commission taking review of the application we've put in front of them and using their discretion to determine the appropriate outcome they see here.
All right, thank you. I'm going to ask you some questions about your bench, the Pepco's response to the bench data request number 1. So I don't know if you have that in front of you.
Yes, I do.
All right, and on in your response to section A there, you state that while the data provided in the company's multi-year plan application captures the company's historical actuals during the 12-month periods, there are several reasons why they do not serve as the basis to support a revenue requirement or electric distribution rates. Do you see that?
Where exactly is that, counsel? Where in the
Okay,
paragraph?
it is like
Oh, I see.
2/3 of the way down the page. It's
see.
right before the.
Yeah. Yes, I'm with you.
It's like the last full sentence on the page, I guess. All right, and you state that the primary reason that you have that opinion is that the 12-month periods that the 12-month periods in the rate case right now do not include pro forma adjustments to rate base revenues and expenses for known and measurable changes that would typically be incorporated into the determination of the revenue requirement when an historical test year is used. Is that right? I was quoting you here.
Yes, yes. I'm just following along with you as we go. Yep.
And then in the citation that you included to that final sentence, you refer to a commission precedent about approving post-test year adjustments to rate base for plant additions that were known and measurable before the close of the hearing. Is that right?
That is right.
All right, and you also state that another reason, I guess a secondary reason or a second reason, is that the historical test years do not include the inclusion of construction work in progress in rate base and allowance for funds used during construction and operating income, and that you believe that along with ensuring the company can recover its cost of capital, are required to set just and reasonable rates for providing the company's Maryland electric distribution service. You see that?
Yes.
All right, and then you go on in the response to sub B to list the adjustments that Pepco had included in its most recent traditional test year base rate case. And that list included adjustments to annualized test year reliability plant closings, and also to reflect post-test year plant closings through the hearing date, also to reflect post-test year plant closings through the rate effective date of the commission order. And would you agree on that last point that sometimes companies have sought that sort of adjustment, but the commission has not approved it?
Yes, to my knowledge, this is an adjustment we typically seek recovery for. That we believe there's merit in, but I do not believe the commission has adopted this to date yet.
Thank you. And then, finally, I'm not going to go through the whole list of 18 items, but I do notice that you have an item on there for the AFUDC synchronization. Do you think Mr. Efron would be surprised at any of the 18 items that you include on your list of adjustments?
Objection, Your Honor. I don't think this witness can, he can testify as to what Mr. Efron would be surprised by.
I understand that. I mean, if you want to take another stab at it.
Sure. Mr. Efron has sponsored an exhibit in this case that I think you just stated on rejoinder that you had reviewed. Is that correct? That the OPC's response to bench data request number 2?
I'm sorry, can you rephrase
Sure.
or repeat the question?
Sure. I believe on rejoinder you mentioned that you had reviewed the OPC's response to the bench data requests in this case. It was filed as OPC Exhibit 34, I believe.
Yes, I do not know the exhibit number, but yes, I've reviewed that and have it.
All right. Do you agree that the questions in OPC's response to bench data request 2 are identical to the ones that you were answering in Pepco's response to bench data request 1?
Yes.
And would you agree that Mr. Efron's conclusion about the ability to perform an historic test year analysis to support a revenue requirement in this case are substantially the same as yours?
Yes. I
And
agree
that
with
is that
Mr.
you-
Efron
it's
on
not-
that point.
Right, and that it's not possible to do it. That you, both you and Mr. Efron agree that certain adjustments would have to be made to an historic test year calculations are not supported by the evidence in this record.
Correct.
And Mr. Efron specifically recognized the lack of the data regarding post-test year closings to safety and reliability plan, as well as the inclusion of QUIP and rate base and AFUDC and operating income. I believe that the reference to some of these are in Mr. Efron's response to bench data request 1. And I can point you there if you'd like. If you turn to OPC's response to bench data request 1.
Sorry, I'm looking at 2. I apologize.
Yeah, no, I think I tripped you up there because that's what I was talking about at first.
Let me just catch up to where you are.
Sure.
Yes, I see where he references safety and reliability plant, et cetera.
And yeah, and then on the following pages where he talks about the QUIP and AFUDC
Yes.
adjustments. And I think you also mentioned that you were present and heard the testimony that Mr. Efron gave yesterday afternoon.
Yes, I heard his testimony.
And Mr. Efron essentially said the similar things that you've included in Pepco's response to bench data request 1 about what is missing from the record in this case for the purposes of an historic test year calculation.
Yes, for a traditional rate case revenue requirement outcome, yes.
Right. Now, you're aware that Mr. Efron has proposed an alternative test year rate structure in this case that is different from an historic test year?
Yes, I am.
Okay. And his alternative is also different from the multi-year plan rate structure that Pepco has proposed in this case. Is that correct?
That is correct.
Do you agree with Mr. Efron that the record in this case is sufficient to support his recommendation regarding an alternative rate structure?
Your Honor, I'm going to object. That's starting to delve into a legal conclusion.
Your Honor, Mr. Lemming has opined at length in this response and in the hearing thus far about whether the record is sufficient to support an historic test year. And now I'm asking him questions about what the record is sufficient to support.
Okay, I'll allow it. Go ahead.
You want me to repeat the question, sir?
Yes, please, if you could.
Sure. Do you agree with Mr. Efron that the record in this case is sufficient to support his alternative rate structure?
I believe he has used information that is in the record to develop his proposal. I think I noted again some of my reasons why I do not support it, and I'm advocating against it. But I think he has certainly developed it based on information provided in the record in that manner.
Okay, thank you. All right, so would you generally agree that there have been three broad approaches discussed in these hearings regarding the rate structure to be used? And those three structures would be the multi-year rate plan that Pepco has proposed, the alternative test year approach that Mr. Efron has recommended, and then an historic test year that is currently not supported by evidence in the record.
And I would note I think AOBA also has a
I
position as well.
I apologize. So 4 approaches, including AOBA's. And you and Mr. Efron both agree that additional information and time would be needed for an historic test year, but that the record currently supports a commission decision to use either Pepco's 45-month MYP or Mr. Efron's alternative. Is that correct?
I'm sorry, can you just repeat
Sure.
the question again?
You and Mr. Efron both agree that additional information and time would be needed for an historic test year calculation in this case, but that the record currently supports a commission decision to use either Pepco's 45-month multi-year rate plan or Mr. Efron's alternative.
Yes, I do.
Now, in Mr. Efron's alternative proposal, he uses the net plant as of March 31st, 2024, as well as the adjusted operating expenses for the 12 months ending March 31st, 2025. Is that correct? As you understand it?
Generally correct. I think I noted on Friday he made some high-level assumptions for how he got back to that March 31st, 2024 balance, but generally I agree that was the intended objective of what he was trying to do.
Okay. Would you agree that a revenue requirement for rate year 1 of a multi-year rate plan that is set using Mr. Efron's approach would result in rates set at a level that are just and reasonable?
I'm sorry, can you repeat that one more
Sure.
time for me?
Would you agree that a revenue requirement for rate year 1 of the multi-year rate plan that is set using Mr. Efron's approach would result in rates set at a level that are just and reasonable?
Your Honor, once again, I'm going to object. I don't think this witness can testify as to what is just and reasonable. That's a determination for the commission.
And I'm not asking him to answer that. I'm asking if the revenue requirement set using Mr. Efron's approach would result in rates that are just and reasonable.
It's the same question, Your Honor.
Yeah, I tend to agree with that. I mean, I think and the part that I'm hung up on actually is this just and reasonable. So you can kind of rephrase
Sure.
it to say, something, get to your point in a different way, but
All right, let me ask it this way. If the commission approved Pepco's multi-year rate plan as filed, including all the adjustments that you've included, so they just took your application and they approved it as you filed it, would you agree that the rate set in this case would be just and reasonable?
Your Honor, I don't think this witness can say what is just and reasonable. That's for the commission
in
to
your,
determine.
In his opinion, would Pepco's case as filed result in a reasonable revenue requirement?
that I think you can answer, so.
Yes, I mean, I believe our position is we have filed a case that is designed to recover the costs that we expect to incur in the investments we expect to make over the course of the MYP. There's some certain adjustments I think I passed around on Friday when I took the stand about things that need to get taken out based on a recent commission decision. Aside from those,
Sure.
I think it's designed to recover those costs and investments we intend to make over the coming years.
Sure, and I appreciate that. So let me ask you this. What would the revenue requirement for rate year 1 be in this case if all those adjustments that you've made during the course of this proceeding, taking out the climate solutions programs, for example, and the other adjustments that you've made through rebuttal testimony and other adjustments? What's your number at this point in this case? And if to help you out, I don't know if you have a copy of the comparison chart. Or if you know the number off the top of your head.
I have a general understanding of it, but do not have the comparison chart in front of me. So if,
I have a copy for you.
Sure.
And I apologize, Mr. Lemming, I only have a small version of it, so.
If you can't read it, we can get you a bigger one.
Yeah, if he wants it, I have it.
So as reflected on the revenue requirement comparison chart, our revenue requirement for rate year one, and again, this needs to be modified to, I passed around on Friday, RMAs 25, B, C, D, and E, as well as RMA rate making adjustment, I apologize, 16 would need to be removed. I believe those add up to roughly $800 to $900,000 ish. We need to come off the page here. The revenue requirement would be with our tax offsets included. I'd say just shy of 68 million after you take out those items I noted.
Okay, and I think you mentioned before that, what would the number be without those tax offsets? Because I think there's a question about whether the offsets would be appropriate depending on what the commission ultimately decides.
Without the offsets, it would be, slightly under, call it just under $111 million.
Okay. So, for the purpose of the next several questions, let's just assume that your revenue requirement is $111 million. I'm not holding you to that. I'm just using it as a reference so we don't have to keep going back or saying a full number. Would you agree that if the rates were set at a level that provided Pepco an opportunity to recover the $111 million during rate year one, that would be a reasonable revenue requirement in this case?
That would be an appropriate revenue requirement to recover the operating expenses and investments that we have used to set and underlie that revenue requirement.
Okay. And so the rate set under that revenue requirement would be reasonable on the first day that they went into effect, the first day of the new rate effective period?
Yes, they would.
And they would also be reasonable on the second day of the rate effective period?
Yes.
And they would be reasonable on the 364th day of the period, or throughout that whole first year of the rate of rate year one, they would be reasonable.
Yes.
Now let me ask you this. Would your answer be the same if the commission made certain adjustments to that number? So instead of approving Pepco's MYP with a revenue requirement at exactly the amount Pepco's requesting, that the amount was lower than that full amount?
Yes, I believe the commission is ultimately tasked with determining, what that reasonable rate is.
Okay. And so let's assume that for one of those adjustments that the commission considered an adjustment to the ROE that the company is seeking. The company is seeking an ROE of 10.5%. And I think Mr. McKenzie has testified in this hearing that he didn't seriously believe that the commission would approve an ROE at that level. Were you here in the hearing room?
I was here when he made that comment.
Okay, and I think he even said he didn't think anybody in the room would expect the commission to set the ROE at 10.5. I believe that the example that he gave was that they might set a lower ROE at 9.8%. Do you remember that?
I don't remember the exact number he threw out, but remember the exchange.
Well, let's just say that the commission did, in fact, set the ROE at 9.8%, but kept all the other elements of Pepco's multi-year rate plan as filed. If that was the case, then the company's revenue requirement would be lower than $111 million.
That is correct.
Would you believe that the revenue requirement is, in this example, is still reasonable, even though it was lower than $111 million? Just with that ROE adjustment. Everything else was the same, but just the ROE changing to 9.8.
I would respect the decision of the commission that is a reasonable revenue requirement under their consideration.
Okay. Now, I'm just going to take this hypothetical a little bit more. I'm not going to beat a dead horse. It's not the last little adjustment that I'm going to make. But what if, in addition to an awarding a lower ROE of 9.8, the commission made a further adjustment recommended by staff? For example, during questioning by Commissioner Suchman, She mentioned that some of the company's justifications for CapEx projects were thin. I think she actually directed some of those questions to you. And so let's say, based on the company's justifications in this case, the commission adopted staff's adjustment to remove $56,000 of electric distribution capital projects for customer operations and IT. And if you look on this chart, you'll see that that's in this comparison chart. So to reset the hypothetical, the commission has awarded an ROE of 9.8 rather than 10.5 and made one further adjustment. They've taken $56,000 from the electric distribution capital projects for customer operations and IT. Would you believe that the revenue requirement that would result from that would be reasonable?
I'd say my position is that our proposed revenue requirement is reasonable, but as I've mentioned, the commission has the ultimate decision here and what that is, and I would respect the commission's ultimate decision.
All right. So would you agree with the premise that a reasonable revenue requirement in this case is not an exact number, but a number that falls within a range?
Again, I think we have a position of an exact number of what it is. I think you're getting other parties do, and the commission will ultimately decide on a number. It will be an exact number at the end of the day, but we have a position for what it is.
Okay, and I think you've said that you would respect the final number that the commission reaches in this case.
Not being able to speculate on any eventuality, but I would generally show deference in respect to the commission's decisions.
All right, well, let me ask you this. If the ultimate revenue requirement in this case falls within a certain range, would it matter how that rate was set? Would it matter how the revenue requirement was set in this case, as long as the number was a number, let's say it was a 111 million, or let's say it was slightly less with an ROE adjustment? Would it matter how it's set?
Your Honor,
Yeah.
at this point, I'm going to object. This has been asked and answered, I
I
think.
understand, and I guess I don't quite understand. I don't understand the question. So.
Sure. If you've testified today that if the commission approves a revenue requirement of $111 million, as you're seeking in this case, that would be reasonable. Would it matter how the commission reaches the decision that $111 million is the revenue requirement that they're approving?
I mean, my understanding, and I'm not a legal expert here, but my understanding is that a reasonable rate is intended to allow the company an opportunity to recover its prudent operating expenses, the investments it's made, and an appropriate return under the commission's determination on those investments it's made. And I would expect that revenue requirement to be founded in some sort of determinations along those lines.
Sure, and I think you and I agree on that point. But as far as if the method that you use to consider that evidence and come up with a number, as long as the number is $111 million for day one of rate year one, you would believe that that's a reasonable number.
Your Honor, again, asked and answered. I'm going to have to object to
Yeah,
that.
I think he has responded that he likes 111 million.
All right. So would you agree that a major difference between a rate set using an historic test year or Mr. Efron's approach is that in both of those examples, the rate would be a stated rate that would be fixed until they were adjusted again in a new base rate case, whereas under your MYP they would adjust over time and be subject to reconciliation?
Yes, I believe that is a difference between our proposal versus. I think Mr. Efron made the point that he was coming up with a number about OPC's proposal. Yes.
Do you believe that the commission could approve your forecasted test year for the first year of the multi-year rate plan subject to refund rather than approve all 3 years of your multi-year rate plan?
Objection, Your Honor. That's asking for a legal determination.
Yeah, I think so.
If the commission approved your forecasted test year for the first year of the multi-year rate plan on a temporary basis rather than approve all 3 years of your multi-year rate case, wouldn't that still promote the transparency that Pepco has claimed as a benefit of multi-year rate plans in this case?
Can you ask that question one more time, please?
Sure. If the commission approved your the use of your forecasted test year for multi-year plan rate year one, subject to a refund or reconciliation. If they approved that on a temporary basis, rather than approved it for all 3 years of the multi-year rate plan in your case, would you agree that it would still promote the transparency that Pepco has claimed as a benefit of multi-year rate plans in this case?
I guess I apologize. I don't understand what is meant by set it on a temporary basis.
If the commission let me ask it this way. If the commission approved a revenue requirement using a forecasted test year just for multi-year rate plan rate year one, instead of approving it for all 3 years of the multi-year rate plan in your case, would you agree that it would still promote the transparency that Pepco has claimed as a benefit of MYPs in this case?
To a degree, but I think to a lesser extent than, as we looked at things 3 years out, that provides more transparency than doing things on a 1 year basis, but I believe there's still transparency in doing that.
Okay. And then would you have a similar opinion regarding setting predictable rates for customers for that first year?
Again, I think it gives them predictability for that first year. It's for a shorter amount of time, and I think it starts to diminish some of the benefit relative to what we've proposed, but I agree there's a degree of benefit there.
And would you also agree that it would allow, at least during the course of that first rate year, for the company to make investments promoting safety and reliability and the ambitious goals regarding electrification?
Yes, I agree.
Thank you, Mr. Lemming. I have no more questions.
Thank you.
So, Walmart. Staff?
Just 2 or 3, Your Honor. Thank you. Good morning, Mr. Lemming.
Good morning.
If we could return to the company's response to bench data request 1, that subpart B that lists those 18 adjustments, just to close the loop on some of Mr. Oslander's questions. You would agree that these rate-making adjustments are usually points of litigation in a traditional rate case, correct?
Yes, I agree, and I've noted I think parties usually conduct a fair amount of discovery on these.
Yeah, so the commission would ultimately approve or reject these specific rate-making adjustments. Is that accurate?
Yes, that is correct.
Yeah, thank you. One more question or two. If you could turn to page 3 of the company's response. On the second to last paragraph, about 3 lines down, it stated, of note, the time to evaluate a traditional test year as prescribed by the Maryland General Assembly is 7 months. The time to evaluate an NYP is 10 months, and the parties in this case have been given 13 months. If the company was required to come back with a traditional rate case, these timelines are predicated on the rate effective date. Would the company need to change its rate effective date if it were required to come back with a traditional rate case? So right now, I believe April 1st is when rates would come into effect, the rate effective date plus the suspension period. Is that accurate?
I don't know all the legality of everything, but I have a general understanding of that. Sounds correct to me.
Yeah, so if the company were required to come back for a traditional rate case, would it be required to change the rate effective date it initially had in its application?
Your Honor, I'm going to object. That's, once again, we're starting to delve into a legal question.
Yeah, and I think the witness indicated he's not quite conversant on the time structure.
Understood, thank you. That's all I had.
Okay. Any redirect?
Very briefly, Your Honor. Mr. Lemming, do you recall answering questions from the for counsel for OPC regarding that if the commission were to adopt Mr. Efron's his alternate rate proposal, that rate would only be in effect until another rate case was filed by by the company?
Yes.
Okay, and that rate filing that could come at any time from the company. Is that correct?
Yes, that is correct.
Okay. Is there a customer benefit regarding rate stability that would be lost if the commission adopted Mr. Efron's alternate proposal?
Yes, I think we've kind of enumerated throughout our application over the past, the past week or so here that, one of the benefits of the multi-year plan structure is that we're able to provide clarity and transparency to our customers in terms of what rate, we'll be charged under that plan over the coming 3 years, and if we were to revert back to a stated rate type environment, they would effectively have no insight into when that rate may change, and when it ultimately does, what amount of change it may be subject to.
Okay. Thank you very much. That's all I have, Your Honor.
So, questions from the commissioners? Commissioner Barbie.
Thank you. Good morning, Mr. Lemming.
Good morning.
Let me first ask about tax treatments. You said a little while ago that a multi-year rate case gives you the ability to rate smooth with respect to tax treatment. Could you describe that to me, because I don't understand that.
Certainly. So we currently have a liability today for amounts owed back to customers as a result of the Tax Cuts and Jobs Act, where we had some deferred tax amounts that are now owed back to customers as a result of that change in tax law. When that change occurred, we came in with the commission, made a filing, and ultimately determined the period that those amounts would be returned back to customers, and an amortization timeframe was kind of set up to say certain balances would be returned over a 20-year period to customers. And there was different methodologies kind of decided upon. One of the things we've looked at is there's a non-protected class of this liability that's owed back to customers that we can have some discretion about the time it's recorded back for tax purposes. And we've proposed to change some of that amortization time so that rather than returning it over 20 years, we've proposed here that we take $42 million and give it back to customers in rate year one as a way to offset that increase they would otherwise see. So we would reduce our tax expense through that acceleration of that liability, and that would bring down the revenue requirement that customers would be experiencing as a result of that reduction of the tax expense.
Well, can that kind of treatment of the tax liability also, does it matter if it's a traditional rate-making year versus a multi-year plan? It seems to me what you've described is something that that application could be used in either scenario.
The challenge with it is that we have only a certain amount of that liability remaining, and if we were to set a rate that returns $42 million in that stated rate, $42 million would be going back in perpetuity until we reset that rate. And so we would be flowing back in excess of the amounts in excess of that liability that exists today.
Well, I mean, there are many plans and treatments, there are many plans of the utility that span more than 5 years or 6 years, I imagine. I mean, you're regardless of whether it's a traditional rate-making procedure or a multi-year plan, it seems to me that the way you would handle this accounting liability would be fairly similar in both instances. What am I not understanding?
I'm sorry.
So my feeling is, I'm an accountant, and what do? We make journal entries, and it doesn't matter whether I'm reporting results quarterly, annually, or over 5 years. Imagine a corporation that only had to, report every 5 years. The journal entry would fundamentally be the same, and I could tailor whatever transaction I'm doing based on how I write the journal entry. And I don't think the period of time over which I'm reporting income and cost should make too much of a difference, I think.
I think I hear your question. Mechanically, the accounting would follow the decision there. I think the point I was trying to articulate is not necessarily that the accounting can't be done that way. I guess what my point was there is that effectively we would exhaust that liability within I think we've said we're doing half of it now, so the other half will be exhausted
in the next
year. And,
right.
The effect of that would be, we as a utility would now have a revenue, we'd have a mismatch between expenses and revenues, such that we're going to have a revenue deficiency of $42 million, that'll have to drive us to come back to remedy that, as opposed to being able to handle it through just a pre-prescribed change in that rate. So we would have to file an entirely new rate case to fix that revenue cost mismatch, as opposed to being able to just have the rates set to do that in advance.
Okay, I understand your position. I'm not sure I agree with it, but I understand your position. Second thing I'd like to ask about is the reconciliation items. And I'm a new commissioner, and as an accountant, I know what reconciliation is. And I'm starting to get the sneaking suspicion that it's different in the accounting world than it is in the rate-making world. So let me just ask this particular question that I think commissioners Richard and Suchman got at yesterday. Let me go at it a slightly different way. Let us say in a multi-year rate scheme, I don't mean the word scheme as a pejorative, in a multi-year rate scheme, there is some sort of, I forget what we were talking about. It was something where the build-out would be over 3 years. We would say the expenditures were prudent in year 1 and year 2, and let's theoretically say that in year 3 it all goes south, and it turns out that what we had deemed as prudent in year 1 and year 2 isn't. So would we, through the reconciliation process, retroactively go and deem those monies as not being in the rate base and as instead being expensed, and then also go and cancel out in the third year the return on and return of not bonuses, rates of return that the utility derived? Is that what the reconciliation process involves?
I'm glad you asked this question, because I think this is where I'm really hoping to try to clarify the process here.
Okay.
As we are building a project, and this goes back to my discussion around construction work in progress, as we are building a project, spending money on it, and it's not placed into service yet, so let's say we've got a substation that's going to take 3 years to build.
Okay.
Just to make it line up with the MYP, it's going to take, obviously, I think longer than 3 years to probably build a substation. If we're building and spending capital expenditures on it in year 1 and year 2, that is not in our revenue requirement, and customers are not paying for that.
Right.
When we complete the project and it's placed into service in year 3, that is when it begins to impact the revenue requirement, be reflected in rates, and customers pay for it. So when we're looking at that project in year 1 and year 2 while it's under construction, we're not assessing it for prudency. The prudency assessment comes when we say it is now in rate base, we are now seeking recovery of it, customers are now paying for it. That's the time where we look to say, was this a prudent investment that should have been made, that was made effectively and well, and should customers be paying for it? And if we say no, we would pull it out of rate base and give the money back to customers at that time. But as we're looking at it in year 1 and year 2, customers aren't paying for that yet, and so there's no rate transaction that needs to happen in terms of saying, well, we don't think the company's managing this one well, and so we're probably going to determine it's imprudent and take it out. It's not in rates yet, so there's no reconciliation to come out of customer rates until we get to that completion of the project. It's placed into service in year 3. Parties then look at it and say, don't think this one was the right one. Let's say it was imprudent, take it out. That would all handle in that year 3 reconciliation, if that makes sense.
Yeah, no, that makes sense to me. But I guess fundamentally the thing that I wanted assurance for, and I think you gave it to me, maybe the example I gave wasn't a good example, but if we do deem something to be prudent in year 1, regardless of whether we're doing multi-year or traditional rate making, if something was deemed to be prudent and then subsequently deemed to not be a prudent thing, we can, through our reconciliation process, back out the transaction in the future.
Absolutely, and I would characterize it as I don't think you're making a prudency determination until you get to that end state. But if somebody feels like, hey, I've said this is prudent, and then later when it goes in service says, nah, maybe not, something happened and it's no longer gone well in my mind, absolutely, that is what this process allows for, that we can do that at that time.
Okay, final question then, and this is the big meta question. Why is, I've taken in everything you've said and your testimony, and I don't see a fundamental managerial difference between traditional rate making and a 3-year MYP. It seems to me that the decisions are fundamentally going to be the same. The accounting treatment and the financial treatment is fundamentally going to be the same. The determinations of prudency and whether an item is used and useful are all going to fundamentally be the same. I'm not understanding what the value add is for a multi-year rate plan.
I think you are right in terms of the mathematics and rate-making principles of how those revenue requirements are set, in terms of the accounting principles. I think you're absolutely right on all of those. I think what we see the fundamental difference between a traditional base rate case environment and a multi-year plan is the benefits that we've seen enumerated through the commission orders that stood this process up, where we're able to provide customers with certainty for what their rates are going to be forward-looking in time for a period of time. We've given transparency into what those plans are that we intend to do over the coming years. And going back to, I think, the order in 9618 that kind of embarked us on this whole journey, if you will. I think the commission had a recognition that, one of their tasks is to balance the interest of all stakeholders, right? And so we're in an environment where we're spending and investing, and those costs are growing over time. One of the things an MYP does is it allows us to better match our revenues with our costs and gives the utility also, the benefit of the commission is noted more timely recovery of expenses and a better opportunity, not a guarantee, because I think we've shown we haven't quite hit it, but a better opportunity to earn our authorized return. And so, it also goes to suppliers, right? We're working with a lot of minority-owned, diverse suppliers that, they get to see our plans going into the future, understand their stability around support from a revenue perspective for those plans. We can engage with them to staff up to get that work done. The multi-year plan construct gives all of those benefits from the kind of customer, supplier, company perspective, and really balances the interest. It allows us to support kind of state policy by being able to invest at the pace we need to, et cetera. And that I think is the fundamental difference that we see between traditional rate making relative to multi-year plans. It's not about the math and the accounting. It's those types of benefits that we see and talk about.
Okay, thank you. And I have to say, Mr. Chairman, it's quite a relief to discover that the word reconciliation is the same in both worlds. So.
Okay, Commissioner Richard.
Thank you, Mr. Chair, and thank you for coming back.
Absolutely.
Let's see. First, I just wanted to make sure I understood your answer to Mr. Greger's question. Really had the same, what happens on April 1st. Now, it may have been the answer is this is legal, and therefore I don't know exactly. But I was just trying to, again, also understand on the various scenarios of a decision we might make. If nothing has been, I guess, publicly articulated by April 1st, what rates are in effect? Do you know what happens on April 1st?
Well, we have a little bit of I'll say interesting dynamic here in terms of we entered into that whole settlement agreement to extend the schedule out. So I think the customer rate change that will be seen is going to be on July 1st.
July 1st. Nothing happens then on April 1st.
Yeah, April 1st, I think under legislation and on our statute,
okay.
I'm venturing out over my skis. Our rates go into effect, but we have offset those for customers, so they're not seeing any impact until we get to July 1st.
Okay. All right.
So we've.
I want to be careful that if this is not your area, then I could just, because I was also curious about the same thing. What happens if we decide, for instance, to say, okay, you know what, we agree with a couple of the parties, and the historical test here is better, and therefore we want you to come back. And my question was, well, what happens on April 1st? If we absolutely just say, okay, we reject this, and the company can decide what it wants to do next. What happens on April 1st?
So April
Okay.
April 1st, I don't think anything will happen, but July
Okay.
1st is
So
where
it's
the
July
change starts
1st.
to occur. What happens at that point probably gets beyond my area of expertise.
Okay, fine, fine. I was interested in your this idea that we could set a duration of what a multi-year plan is. Is that discussed? Did you discuss that all in this document at all? The duration issue. I just was. This is your the bench data request.
I don't know if it's in the cover letter here, but I think that's kind of, at least in my interpretation, denoted in order 89482 that said they
Okay.
can be up to a certain duration.
Up to a certain, okay. And for this case, if we were to kind of look at our duration, and maybe it's not multi-year, it's multi-month rate plan. So if we go like a 12-month or 18-month, how would that work with the record we have right now? All the parties have set out, an approach to multi-year rate plan. Will we just take one of those, or a hybrid of those various proposals on a multi-year plan, and just say, okay, this up through 12 months or up through 18 months? What are the logistics on that?
I guess the way I would think about it is, we've got the company's proposal. Parties have all, I think, put forth their positions for how they would alter and modify that we've asked the commission to take consideration of. As you deliberate that and decide on that, that'll be used by you all to generate what you think that reasonable rate is that we were talking about earlier. I think if you say, hey, it should be, 24, 18 month, 12 month, whatever that period is, I think we would take the rates generated by that decision and say these are the rates in effect for this 12-month period. Then as that 12-month period expires, we'll look at those adjustments and positions again and say for this next period of however long duration that may be, this is what that rate would be set at, and then kind of specify in your decision what that end time is that you'd look for that plan to end at, and for us to have to come back before you.
Okay, for the duration. But what if it's something along the lines we tried to estimate, okay, this is when we think a lessons learned proceeding would be concluded and we'd have some outcomes. Would it be like 18 months and then we just order the company to come back at that point in time? Is that an approach that that the company would contemplate?
Yeah, I think there's tremendous flexibility in this whole process here, right? There's, as we just talked about, you can set, that rate for that first year, another rate for the second year. You all can determine what that appropriate time is for that. Ultimately, if the lessons, and you can try to, time that up with the lessons learned process if that's the desire. And then if the timing changes and those things don't line up, I think the commission always has the discretion to say, hey, we want to call the utility back in now that we've gone through that process and have a review of things as well.
Okay. And then I believe this was probably mostly covered in the rejoinder and some of the cross, but again, looking at the testimony from Mr. Oliver and Mr. Efron, is there anything new that you heard in the live testimony that you would want to respond to? And again, I think you largely answered that, but I'm kind of interested in just focused on what happened here during this proceeding, that we can be, informed of the company's position on where these programs or where their proposals stand in the eyes of the company.
I don't know that I would say we necessarily, heard anything new from Mr. Efron. Got up, I think he explained his position. We responded, or I responded to that at least a little bit earlier. I think it was helpful to hear from Mr. Oliver. I think we had gone on record testifying we weren't clear as to what they were proposing and understood kind of how he got to his positions, and that, they intend to, fully articulate those as well on brief. And so I think we're going to have to wait to see for that brief to see if those hold as their positions or if they'll change anything anything here. So hopefully that helped answer
No,
your question.
no, that's important, important answer. And then also in the OPC response to our data request, was there anything in that that was new to you, to the company, that wasn't already in the testimony, submitted by OPC?
I mean, I'll try to stay away from the cover letter, as I think the lawyers have denoted. There was some matters that they'll probably discuss in there in terms of the response to the data request. You know, I don't think there's anything new that's popped up in here. I think Mr. Efron and I are very well aligned on what information is in the record or not. You know, the only thing I you know, might add is I think there's been some discussion around the construction work in progress and AFUDC issue. You know, we've gone in and looked, and I think it's typically a balance that's about $50 million across a year for us that we're arguing is what is missing here. But I don't think there's anything anything fundamental I have seen in this response from Mr. Efron that I think we're misaligned on in terms of what's in the record or not and how these things work.
Okay, and did it change any of your views on whether it's unjust or it's arbitrary or undefendable?
I certainly have a better appreciation for his approach now that it's been articulated. It's not one that I or the company support, but do understand how he's gotten to the conclusions and recommendations that he has, and understand he's used the information he's got in the case to get there.
Okay, when you say don't support, is it because you'd prefer to have a multi-year rate plan, or is it because there's some flaw in the?
I think it's our view that the multi-year plan, I was saying before, it gives you the opportunity to cover your costs and investments, and I think that's what we're saying is, we think that's the way to do it, but I understand what he's saying.
Okay. And then I think, so this was part of your live testimony today. So this is what comes from the order. I guess where I've been approaching this and asking questions, I guess where I was trying to understand is how it's being applied. Not necessarily, I know very well what was in our order as to what we envisioned in the pilot, but it's just the application. In hearing some of the responses from the intervening parties, do you think there was a consistent way in which the various parties are applying this, what was envisioned in the multi-year rate plan? Or do you think that there was some kind of variation in approaches, the way it is being applied at this point with respect to this specific case? Because we're not talking about the bigger question of MYPs. We're talking about this specific case.
I certainly don't want to speak on behalf of the parties, but I think what I've heard from at least staff witnesses, Austin and Riley yesterday, I seem to understand the process they went through to review the projects, try to understand the basis in our execution of those projects and how they applied them here from a reconciliation standpoint. And I think that sounded consistent from what I also heard from the combination of OPC witnesses, Stevens and Alvarez, in terms of them looking at the projects we were doing, recommending there were certain ones that they certainly didn't agree with, and they're entitled to their review and position on that. And working with Mr. Efron to say here's kind of the amounts we're proposing to adjust from the company's reconciliation proposal as well. And so I think, I look at those and say parties certainly formed their own positions, but they were using the information kind of available through this process here in a manner that, seems generally aligned to me to review the spend, review the project proposals we have, the justifications and documentation for them, to serve as the basis for those recommendations they've put forth.
Okay. And would you agree, this is the substantive case to the first Pepco's application. So we are doing for year one and year two both a reconciliation and some prudency review. Is that correct?
Yes, of those projects that have been completed in year two, and we'll handle the review of the ongoing projects that are going to be completed this year when we do that final reconciliation.
Okay, and you
yes.
heard some questions here. Then we're going to get to the very end of the MYP. Are we going to have a go back to year 1 and 2 for prudency, and then also look at what happened in year 3? And I mean, is there a prudency on the prudency? I don't know.
My at least read of the commission order, and I think I laid out there were 79 through 81 were the paragraphs in the order. I think 81 kind of lays out that the final reconciliation is really just meant to, and prudency review, is meant to focus on those periods that had not yet been reviewed. I certainly don't want to speak for the commission, but I didn't read that to interpret there would be another subsequent review of year 1 and year 2 again, and that final review would be isolated to year 3 to try to, at least as I see it, keep that a process, efficient and not rehash issues that had been looked at previously.
Okay. Well, and that's why I'm already trying to understand. I mean, hopefully we'll have a more thorough examination of this process in the overall review of MYPs, but since we're kind of faced with it already here by a non-pilot utility, I'm just trying to see how parties are applying this. I mean, to the example that Commissioner Barvey used, we did talk a little bit about one of the programs being the smart sensor program, and at this point, it seems that we are going to be accepting into a revenue requirement, if I'm understanding the company position. But we haven't concluded, whether or not, I think it was referred to at this point, they may be just dumb sensors until we actually finish the program. So they're in the revenue requirement, and then we're going to get to the final year or a subsequent year. That's when I guess a final prudency. How is the company envisioning this process working in a circumstance like this?
I think it would ultimately be based on how we look at that program, right? And I don't want to speak for staff, but I think they've said they wanted to be able to take an evaluation of it over time, right? And so we're something where we say we're going to take an evaluation of that over time. I think it's probably appropriate to look at it at the conclusion and say, how has it gone? Let's make that prudency determination there when we get to that point. And so I draw that contrast to another type of program.
But they're in rates assuming the proposal is accepted by the company, they would be in rates. So they're, but the program would not have been completed yet, or that review would not have taken place, correct?
That's my understanding of the proposal, yes.
Okay. All right. Well, thank you again for coming back, and thank you, Mr. Chair.
All right, thank you.
Commissioner Schlichtman.
Morning, Mr. Lemming.
Good morning.
And thank you for coming back, and thank you for responding so quickly to the commission's bench requests. So that I understand the conversation that you had with counsel during rejoinder, putting a historical test year into your filing would have been inconsistent with what you were proposing in a multi-year case. Is that why you did not put it in?
I think the distinction, at least as I'm trying to articulate, is between a historic test year versus a traditional base rate proceeding. A historical test year is I think that it's a historic period of 12 months of actuals, and we look at that. And in a multi-year plan, we use that to serve as our baseline to kind of project from going forward.
Right. No, I understand that you had right, but you did not offer a proposal based on a historical test year because it would have been inconsistent with what you were proposing in a multi-year. Is that I just wasn't clear about why the question was being asked and your response. So I'm just trying to get clarity on that.
I think the reason we had the question and answer was just to make sure, I guess, and articulate in our view what the difference is between a traditional base rate proceeding and a multi-year plan, to explain why we don't have the record here to decide that. I think we just wanted to make sure that was very clear about
Right,
why we didn't
but
have
you,
that information.
but you could have submitted that in this case.
Yes, we could have, but effectively it would have been having two rate cases at the same time before the parties.
Okay, and is that what's going on in the district? Do you have two rate cases?
Effectively at this point, we had filed a multi-year plan application on a certain date, and just at that, we were subsequently asked and directed to file what would have been a traditional test year rate case proceeding. At the time, the procedural schedule was kind of started at the beginning of the proceeding. The commission asked us to put that together and put it into the proceeding.
Okay,
as
and
well.
how extensive was, I mean, are we talking about multiple witnesses, multiple exhibits? Is that what was involved in doing the historical, in addition to the multi-year?
Yes, it was effectively another rate application where we received the order on I apologize, July 28th, I believe it was, and delivered that to the commission on October 16th, and worked as expeditious as we could to do that.
Okay.
Given, in DC there's no statutory timeline, we were trying to maintain the schedule and had an incentive to do so, and it took us until October 16th to be able to put that case together and put it
Okay.
in, and it required new revenue requirements, new rates from our rate design witness, and new testimony from various other witnesses in the process as well.
Okay, that was helpful.
Yep.
Yesterday you said you heard our conversations, questioning of staff witness Austin, who I think might have also been a little bit confused about what he was reviewing, or at least it seemed to me in terms of year one and year two of MYP1. So your explanation about what you review was incredibly helpful. So thank you. And he reviewed a spreadsheet of the projects, which I don't believe is in evidence. Is that your understanding?
I cannot speak. I didn't see the spreadsheet that
Okay.
Mr. Austin had with him. I apologize.
All right. It would be really helpful. I think our advisors are not worked hard enough. So I'm going to ask you if you can provide some additional information so that we can work them a little bit harder. So that would involve the spreadsheets. If you have a spreadsheet that can kind of lay out what the projects that they reviewed for year one and year two, so that we can just have a general sense of what it was that you submitted, and what you've identified as completed projects that are used and useful, and those that are still ongoing. Is there, without I don't really want to totally overwork them. So do you have some kind of spreadsheet that can kind of just lay that out? That would be incredibly helpful.
I just
for
want to
us.
make sure I'm understanding the request so we get it right. It's basically a segregation of those projects that were completed in a year versus those that still are ongoing.
I heard sort of 150 projects or 300 projects. I couldn't quite, and I'm assuming a lot of those are very small projects. That so if you have sort of an easy way for us to just kind of review what you provided the parties in terms of year one and year two, so they can kind of just look to see what it was that you are talking about in terms of what projects were completed in year one, what projects are completed in year two, and then what projects won't be completed until year three or later. That if you've got a way for us to look at that, so that we can have that can be in evidence as well.
I think the way I'm thinking about it, and I just want to make sure this meets what you're
Yeah.
looking for, is our annual informational filings give that kind of list of projects that we were spending on, and I think it's the in-service date. We're looking for those that went into service during
That
year
that
one,
year,
and rate year two.
and what's not in service.
Yeah, and so what's not in service would be the remainder of that list. Okay.
That would be great. Yes. you talked a little bit about the benefits of a multi-year plan in terms of rate certainty. So customers can kind of see that this is what's going to happen for your rates. But that doesn't include the reconciliation piece. Is that correct?
So the way I would look at it, when we have an ultimate order in this case, if it includes reconciliation and multiple years of rates, those let's assume 3 years. Those 3 years of rates will be kind of known coming out of the order, and we'll have those reconciliation amounts coming out of the order as well. So at the time we get this order, all of those rates and amounts will be known, and we'll be able to put into our tariffs and make it available for folks to review and be able to see. I think the piece we won't have yet is that final reconciliation of that third rate year period.
Right.
And I think in the commission order, it's been noted that we can handle those on a case by case basis and determine the appropriate way to have those reflected in rates, such that we can promote rate certainty for customers. I don't think we're locked into.
Okay,
any
so
certain-
what is your, that was going to be my follow-up question. What is the mechanism you think Pepco will try to utilize in terms of getting that amount reflected into rates?
I don't think that's an position we've worked through and come to a recommendation on yet, but I think there's a couple possibilities, if you will, right, in terms of you could propose to amortize that over a number of years to keep the impact smaller. We could propose to have that go into effect at a certain date in the future when customers can see and plan for that, as opposed to having it kind of just go in right away after approval. So I think there's a few different alternatives we could work through evaluating for what the right way is to handle
But that will cause rates to go up. I mean, you're not gonna have a reconciliation that's gonna ask us. I mean, you could for us to lower rates, but presumably it's gonna go in one direction.
Yeah, and I guess I was trying to articulate we could have that line up with another commission decision on something if we wanted to, or find a way to keep it smaller if it's going to happen sooner.
Okay. You spoke with Commissioner Barve about the tax offsets, and you want to use these liabilities to try to smooth out rates over a 3-year period. But you could, I mean, if we did a 1-year forecasted test year that looked like it was going to reflect a big bump up in terms of what ratepayers will be paying, it doesn't have to be the 42 million, it could be less. You could use some of that tax liability. I mean, I understand what your concern is, that using a 1-year forecast test year could involve you not coming back for several years because you don't need to, and so then you've got that 42 million applying every year. But there could be less to try to smooth it out. It doesn't necessarily have to be 42. It could be 20 million.
I think that's generally correct. I think we could evaluate that and need to determine kind of what that amount is that wouldn't cause an immediate need to reset that rate to correct that drastic amount.
Okay. Now, you responded to questions from OPC counsel on the OPC proposal, and then you also spoke a little bit about the AOBA proposal. I was wondering if you can speak a little bit to how each of those proposals, if you know, would affect Pepco's ability to recover their costs. Clearly, you've got a revenue requirement in there that reflects what you think is needed to recover your costs. And so I'm wondering if you've thought about how those two different proposals would affect your ability to recover your costs.
So I think there's a number of different ways to or factors to kind of go through in that question. I think and I'll try to be as concise as I can in going through them. But if you look at, I think, what OPC is recommending, Mr. Efron has described setting our plant balances at March 31st, 2024, if I have that correct. From our perspective, as rates go into effect and we're spending throughout the remainder of this year and into 2025, we know we're going to be making plant investments. We know things are going to be going into service. You know, we already have stuff sitting up in construction work in progress that we're planning to be putting into service soon. As those assets go into service, the OPC proposal, we would say, you know, makes it harder for us to earn that authorized return because we don't have a return on that plant balance built into rates. The depreciation expense that comes from that project isn't built into rates, and so those create what we always call regulatory lag, where we're not able to recover those expenses as they're incurred as rates are designed that way. Beyond that fundamental construct, I think you then start to get into each of the adjustments that parties propose, where you know, I think OPC has proposed a number of O&M reductions as well that it seems AOBA, it looks like is adopting as well in their position on the chart. And to the extent I think you heard Company Witness Barnett talking about, you know, we're confident we're going to be spending those amounts. If those get taken out of rates, if you will, those are expenditures we'll be incurring that we don't have, you know, from our view, a rate set to help us recover those. And so those are the items that, or at least how I would think about our ability to, or the difference in our ability to recover our costs under the various proposals from the parties.
Okay, all right. That is all I have. Thank you, Mr. Chair. And thank you, Mr. Lemming, for coming back in.
Yeah, thank you.
So, looking at your chart, in MRP year 3, you said that the difference between the two colors is you have actual results up to a certain point, and then I guess it's forecasted after that.
Yeah, it's the kind of the MYP forecast, if you will. It's still kind of ongoing.
So, in looking at where the line is, it looks like that's like 9 months of actual and 3 months, more or less.
Yeah, and I can't speak to how precisely the chart was put together. Well, maybe I'll let you answer your question before I try to get.
Well, that was sort of my question. I mean, you know, in year 3, how much actual results are we going to?
So we haven't filed rate year 3 yet because I think as we look at this chart, I view this, at least personally, as a kind of graphical depiction. When we do rate making, we look at 12-month test periods of time, right, to look at a year of operating expenses, year of plant balances. So we haven't included anything for rate year 3 in this case because we don't have a 12-month period for rate year 3 to look at.
Okay.
When we do have that full 12-month period, that's kind of the standard for how we do rate making, to say, have we earned a return, have we over-earned money back to customers, et cetera. Once we have that full year review, we will file all of rate year 3. And so I would kind of move this shaded line back over to the start of rate year 3 and say we're going to bring that into our final reconciliation and prudency review in July.
I see. Okay. And so the company filed a request for a 45-month multi-year rate plan, but as you mentioned a number of times today, you know, we have the ability to grant something less than that. So I guess my question is, at what point does it not become worth it from the company standpoint to have a multi-year rate plan? I mean, if we start moving in the direction away from 45, you know, at what point, from your standpoint, is it just not worth the aggravation, so to speak?
You know, I think having a forward view of things in general is beneficial. I can certainly understand. I know, and I think I talked about it in my direct testimony, that the 45-month proposal was intended to, you know, help with some dynamics that I understand is kind of beyond what was contemplated, and so I appreciate that's a thing for folks to review and may not be accepted. But you know, I think it's a degree of benefit, right? And I think it's all beneficial looking forward. I think you kind of get the most benefit in terms of transparency and predictability by going out to 3 years. Mm-hmm. I think you still get that benefit by going out to 2 years. It's just diminished relative to 3, and the same thing from 2 to 1. So I think from my perspective, I'd say I think there's kind of benefit and forward views of things for stakeholders and parties. And it's just a matter of, you know, how much of that benefit do we want to, you know, have available and accrue.
Okay, all right. Okay, thank you very much. So, anything else?
Nothing from the company, Your Honor.
So, So actually, I have a question for Walmart. Do you have any update on your court order?
We do not at this time, but what I intend to do once we get the order is to file it with the commission and file
Okay.
a letter notifying the commission.
Okay, fair enough then. All right, so anybody else got anything? All right, well, thank you very